The founder and managing director of Ulrich Roux Associates, Ulrich Roux, joins us to discuss this. Ulrich, great to have you. Thanks very much for your time.
Hi, good morning, Anne. Thank you for having me.
So, Ulrich, this plea was Zuma's second move to have Downer removed. Give us your view on what actually transpired yesterday.
Yes, so as you correctly pointed out, he brought an application in terms of Section 106 of the Criminal Procedure Act during October last year, in which he said that Billy Downer was not impartial and he was not an objective prosecutor, and accordingly he should be dismissed or recused from the case so that he cannot prosecute Jacob Zuma. That application was dismissed in October last year already, and yesterday's ruling was on an application for leave to appeal that decision by Judge Koen, which quite correctly was also dismissed. And the judge made it clear that should Mr. Zuma still believe that Billy Downer is not impartial and is not an objective prosecutor, then he's welcome to raise that during the actual trial. And this has been the narrative of our courts and the National Prosecuting Authority throughout. Remember that this matter, first started basically in 1999, is when the crime allegedly started, and it dates back to 1999. In 2005, Shabir Sheikh was convicted of fraud pertaining to the similar set of facts. And throughout, Jacob Zuma has tried to derail the prosecution, tried to frustrate it, tried to kick the can down the road, as we say. And the NPA and the courts have been firm that should he not believe that he's being treated fairly, and should he not believe that the right procedures are being followed and that the right people are prosecuting him, then he should raise that during the trial. And that was confirmed once again yesterday with his application for leave to appeal being dismissed and the criminal trial being set down to start on 11 April this year.
So, I mean, basically, in handing it all down, Koen said that embarking on an appeal process would be a waste of time, particularly if Zuma was acquitted. Do you think this would be a waste of time? I mean, to take this any further after what was said yesterday?
Yes, so the test also is whether there's any reasonable foreseeability that a higher court will reach a different conclusion. And that is the test that the court needs to apply when considering an application for leave to appeal. But yes, I firmly believe that it will be a waste of time. I believe that most of these interlocutory applications and sideshow issues have been a waste of time. It's been confirmed by courts that it has, because the matter is still proceeding. And yet again, this will be as well, but nothing prohibits him from now approaching the Supreme Court of Appeal on a petition basis to review this decision by Judge Koen. And I think we would be very naive if we thought he was not going to do that.
Yeah.
So we could expect that, in my opinion.
Yeah, I mean, that was my follow-up question to you. I mean, it's a tactic that we've seen all along being used by Zuma's defense team. You know, it is taking it and drawing it out and making it, appealing and going forward and finding another court and doing all of these things that have really prolonged this whole situation for many, many years. So, I mean, that is very much so. We can expect that that's what's going to happen next.
Yes, definitely, and it is ironic because Jacob Zuma has also, throughout said that he wants his day in court and he wants to prove his innocence and he wants to show the South African community that he was not involved in any corrupt activities. But yet the matter just keeps on getting delayed and postponed and kicked down the road. So, just very ironic indeed.
Yeah. The NPA says it welcomes the judgment. It says it was unprocedural to approach the court on the specific matter instead of waiting until the end. Perhaps you can help us understand this. What's going on there?
Well, that's exactly as Judge Koen also pointed out, that, should he believe that he is not being treated fairly, and should he believe that Advocate Downer is not impartial and objective, then he should raise those issues during the trial. The trial has not even started in this matter. As I said earlier, it has been set down to commence on 11 April this year, and those are all issues that can be ventilated during the actual trial, and not in a interlocutory application as he has done now. And that is why the NPA also welcomes it, because they want this trial to start, and they want the state to start presenting its case, for witnesses to start testifying, and for the normal procedure to be followed when a criminal trial commences. So yes, they definitely would welcome this decision.
So if we look further into what the NPA are saying, they do say it would be regrettable to actually take this matter to the Supreme Court of Appeal, because that will lead to another delay. We've spoken about this, which would move away from Judge Piet Koen's order that the case should sit in April. If they go to the SCA, as the foundation has said they will do, and as we've also sort of speculated they will do, approximately how long will this aspect of Zuma's case on Downer's take before his corruption case actually begins?
Yes, I think that is the whole strategy of Zuma, is to just further delay this trial from starting. So if they do approach the SCA, I do not believe that a decision will be handed down before the 11th of April. The timelines are just too short for that to be the case. And then he would have succeeded in further delaying the commencement of this trial. So definitely, if he does approach the SCA, in short, and to answer your question in short, then the matter would be postponed yet again, and the trial would yet again not start on the 11th of April.
So the foundation goes further on to say Zuma didn't invent the interlocutory order, which allows him to apply for this application within his main case. Therefore, the NPA can't blame him for using a piecemeal approach as he uses the legal avenues entitled to him. Is this fair reasoning?
Well, one could argue on the one hand that the mechanisms are there for him to use. He's certainly, I think there could be a strong allegation made that he is abusing the law and the Criminal Procedure Act and the court process. But those options are available to him, as correctly pointed out by the foundation. It is just that, the way that he does it is purely to frustrate and prolong matters. It is not to, in my opinion, to reach an actual conclusion in the matter. Yeah. So he's using every method there is and every mechanism and every loophole in the Act and the court structures in order to delay this matter. So it is a fair comment if one has to look at it from that angle, yes.
I suppose he is entitled to it, though. I mean, that's his right. Those are the laws. So I suppose every avenue that he can use, he will use. Yes,
definitely. There is also a fine line, though, between a person who's exercising his rights and his options compared to a person that we refer to as a vexatious litigant. So in other words, would take on any litigation, would take on any application or launch any court application or procedure without there really being a reasonable prospect of success in it. And an example of this is not related to this matter, but when he was held in contempt of a constitutional court order last year, he approached the Pietermaritzburg High Court in order to review that decision by the constitutional court, which is procedurally just completely incorrect. No high court can overrule a constitutional court order. The constitutional court is our highest court in our country. And one then has to look at the possibility that he purely did it just to frustrate proceedings and frustrate the system, which seems to be the case here as well, I think.
Yeah. Ulrich, let me ask you as a lawyer, and I ask this in the nicest possible way. Wouldn't you do it if you were Zuma's lawyer? Wouldn't you do the same thing to try and buy as much time, take every avenue that the law has to offer for your client?
Well, we as lawyers are creatures of instruction, and we act on our clients' instructions, and we give them options and possibilities within the confines of the law of their rights and their entitlement to try and enforce those rights. So if my client instructs me in that regard, and there is a possibility that one can launch such an application, then you're 100% correct. One needs to advise your client in your capacity as his legal representative. And if there is a possibility or an opportunity to bring such an application, then yes, I would certainly do it.
Absolutely. Final question, the prospects of him succeeding at the SCA, what do you think they are?
Sorry, you just broke up earlier.
The prospects of succeeding at the SCA, if he in fact does go that route, what do you think they are?
No, I think less than zero, to be honest.
All right, legal expert Ulrich Roux, always a pleasure chatting to you. Thanks so much for coming on, providing legal know-how following the decision of the Pietermaritzburg High Court yesterday to dismiss former President Jacob Zuma's application. Zuma applied to appeal an initial decision that dismissed his application to have State Prosecutor Billy Downer removed from his corruption trial.